The fight between OSP and Attorney General Abusia and some bebre eguso koso and rather yeba eba be breaking nina admamo. It sounds so there is much interesting moment ahead. Aha Gossip Politics TV. So unsubscribe here, subscribe and hit on the notification bell so there any updates be able dropping also once a bit to me aka Abusia and rather yeba eba be breaking edimamo high court ruling against OSP ne fine our so a fine no abusia ene yeda sorry ya OSP kisi ejabin say eye high court no ascrape eye ne prosecutorial power wa order ne say on hand all over his criminal cases to attorney general no ene yeda sorry ya OSP kisi ejabin or say onti ase ene onti ase china entino Oko akwa challenge the ruling of the High Court and ya project the 2 year screen no and change the office of the special prosecutor OSP is challenging a High Court declaration that it lacks prosecutorial powers. Abusia entino OSP kisi ejaben or say on ho emma High Court emfa nanimu emba meye from na Attorney General the wa Attorney General nani sibisa na ase na dwuma na oye nyina no nani esa no onte ase entino wa file documents ode kwa kopie mu High Court ode challenge the ruling of the High Court abusia enye asam keto akra entino ensem bebre ebobo amame yakona yenkonkotie ensem ekoso on the challenge of the OSP's and as a High Court ruling on OSP enye asam keto akra mame yakona na yenkonkotie na yisi ade Attorney General no wada oda no wada na kunyam na chese we relaxing na all three HSA OSP nkwa mama yankona yankokoti ensema ekoso
exactly what the outcome will be. But an Accra High Court earlier today, the decision questioning the prosecutorial mandate of the Office of the Special Prosecutor is sparking intense debate and concerns about what this means for the fight against corruption. Here's the reason why. The court today ruled that the Office of the Special Prosecutor requires authorization from the Attorney General to conduct a case currently at the Criminal Division of the High Court. Now, this particular case has to do with the rice scandal, which a couple of people are standing trial. Now, the OSP has served notice of challenging this ruling. Now, the Supreme Court is meanwhile expected to hear a case raising similar concerns about the powers of the OSP. That is tomorrow. This substantive matter, which will be heard by the Supreme Court tomorrow, and this is one that we're keeping a close eye on, and how things are playing out regarding this particular issue, and especially because of the matters that some members of Jonathan, in fact, anti-corruption crusaders have raised. It's one that we keep an eye on quite closely. Now, a bit more on this. There's this case the OSP is prosecuting. Now, that's the Republic versus Issa Seidu and 3 others. Now, this is the rice scandal case. That's at the heart of what happened earlier today. Now, the accused persons in that case asked the court to dismiss the case, and they are raising questions about the prosecutorial authority of the OSP. The OSP doesn't have the prosecutorial authority to even haul them before the courts to answer questions about this rice scandal. The court today took the view that because a matter raising the same question was pending at the Supreme Court, it would rather adjourn proceedings and await the Supreme Court's ruling. That's what happened earlier today. Now, one of the accused persons then filed a process at another High Court. So you need to pay attention to the trajectory of events. Now, the General Jurisdiction Division, now, a quo warranto application, essentially, this is an application which basically asks a person to show by which authority he purports to exercise some power. So what this other accused person was asking the courts to do, the High Court to do earlier today, was questioning the prosecutorial authority of the special prosecutor. It is this application which the court concluded earlier today that the OSP does not have the prosecutorial power in the said case because it has not been authorized by the Attorney General to prosecute this particular case. If you recall, there's this substantive case already which I referred to earlier. So this main case about regarding this prosecutorial power and the mandate of the special prosecutor will be heard tomorrow. That's the Supreme Court decision being looked at or expected in the case of Noah Tete versus the Attorney General. Now let's have a conversation on this because there's been a number of reactions to it and a number of people who have posted on this particular issue. Sami Darko as well, who is the Director of Communications and Strategy at the Special Prosecutor's Office, put out a statement earlier today indicating that they were going to appeal this particular ruling, which we'll get into it shortly. Also, Martin Pebo, private legal practitioner, is joining us. Justice Abdullahi is also a lecturer, a private legal practitioner, is joining us. Edem Senanu, also an anti-corruption crusader, the co-chair of the Citizens Movement Against Corruption, also joining us. Gentlemen, good evening. Thank you for joining us here on Ghana Tonight. It's a development that is taking various sides right now, but I'll start off with you, Justice Abdullahi. First, is this a matter you can say the High Court has the jurisdiction or the mandate to handle? I mean, this particular development earlier today, because one of the questions that was asked was the High Court's powers to even hear this particular case, especially because there's a substantive case at the Supreme Court on this same question of the prosecutorial powers of the special prosecutor. Does the High Court have the jurisdiction to handle this matter?
It comes in this way. If you're dealing with the issue of co-warrantor, indeed the High Court has jurisdiction to make a determination of such reliefs by, in fact, the High Court is indeed arguably one of the institutions that has authority, apart from the Supreme Court, to issue those writs of co-warrantor certiorari, among other things. And so, yes, from that angle, I agree that the High Court has jurisdiction. But now the High Court has jurisdiction to do what it did because people are arguing that it amounts to interpretation of the act. And I tend to feel inclined with those making that kind of argument because I feel that the decision of the High Court invariably amounted to an interpretation of the act. And then I was of the stronger opinion that because it is in relation to the Constitution, such interpretation should have been reserved to the Supreme Court before final determination is made of the application that was before the Supreme of the High Court. That is my opinion on that subject. Having said that, of course, there's also the argument that this was not an issue of interpretation; it was simply an issue of applying the necessary provisions within the OSP Act, and so not necessarily interpreting it in relation to the Constitution. Of course, these are two different strands of argument, depending on which school of thought you belong to. If you may advance your argument towards that line, and this is the school of thought that I belong to. That indeed the conduct of the court amounted to an interpretation, and so it did not have jurisdiction on that. Now, on the main issue, whether the OSP needs to have the express authorization of the Attorney General before mounting any case against anybody or prosecuting any case. My position is this, that per the nature of the act, there is an implied authorization to the OSP to do what it does. Indeed, anything short of that, for me, is difficult to swallow, and it's difficult to swallow not only on the basis of the impugned provision, but also with the intention behind the act. And I mean, lawyers will tell you that you are not to reduce yourself in interpreting an act to just the text that is before you. You are allowed to go into the intent of the framers of the act, and the framers of the act sought to give that implied authorization of the Attorney General to the OSP. Indeed, if you remember, at the time of enacting the Act, these issues were at the forefront. And the issues of the independence and otherwise of the OSP, these were thoroughly discussed by all stakeholders. And because everybody admitted that indeed, without the AG's authorization, the OSP would be a useless institution and it will amount to nothing, really. It will just be existing on paper without any to bite or do anything if you like. And so this is the reason why this express authorization or implied authorization was included in the Act. And so if you want to interpret the Act and you want to limit yourself to the provisions that you rely on and say that per your interpretation or meaning or an understanding of that provision, the OSP must necessarily go for the authorization from the AG, it would have defeated the entire essence of the Act. The entire existence of OSP is defeated by that kind of interpretation. And you cannot interpret the Act to defeat the existence of the OSP. This is why I am of the strongest opinion that that interpretation is wrongful. Can you imagine if the OSP, for instance, gets up one day and says that, okay, I'm going to the AGs for authorization. And the AG says that, okay, you know what, I'll give you a time-bound authorization. So you have my authorization to prosecute cases for 1 month. And then after that 1 month, come for my review before I grant you further authorization for any other prosecution. And in fact, come for periodic authorization. I mean, what would be the essence of having the OSP then? Or the OSP have to go to the AG on every given case to seek authorization before it prosecutes that case. What would be the essence in having the OSP under such circumstances? And so these kinds of absurd results that could be gleaned from the interpretation that the OSP needs the express authorization. Mind you, we are not saying that the OSP is completely bereft of or is completely independent of the Attorney General. We admit that per the constitutional architecture, you need the AG's authorization to do anything in relation to prosecution. But what we are saying is that the Act has already granted that from the AG. Let's remember, the AG is the promoter, was the promoter of the Act.
I see, and just 16, which marks the next pricing window for the month of April. Under the directive, government will absorb 2 cedis per litre on diesel, okay, and then about 36 pesos per litre on petrol. And this is a statement that was signed by Felix Kwachofosu, the Minister in charge of Government Communications. Richmond Roxon, private legal practitioner. Also, he is the Director of Corporate Affairs for the Ministry of Energy and Green Transition. Mr. Roxon, good evening.
Good evening to you, Alfred, and good evening to your Chavich viewers.
First of all, 2 cedis per litre on diesel, 36 pesos per litre on petrol. How much does it translate into a gallon? How much will be going off?
Basically, if you look at the gallon we use in Ghana is 4.5 liters. And so what it will mean is that if you take diesel, you are looking at about 9 Ghana cedis. That's the intervention that has been cushioned by government. And then for petrol will be 1 cedi, 72 pesos. I mean, these numbers will be unprecedented. I cannot recall any time in the history of the country where there's been such a significant intervention when it comes to price of fuel. But this is not surprising. This is His Excellency the President, John Dramani Mahama, who is President of the Republic. And he's always been people-centered. If you look at where he took the price of fuel from and where he took the Ghana cedi from, which are the 2 main drivers.
Okay.
Aside the international prices, you've seen that we have seen prices come down by about 40%. And so with what's happening on the global market and how it's been rising, it's been a concern for him. And that is why he called the emergency cabinet meeting to be able to take this decision.
But I have seen a statement from the Chamber of Oil Marketing Companies. They say that tomorrow being the next pricing window, petrol would have gone up from the current 13 cedis 30 pesos to about 14 cedis 37 pesos, 14 cedis 40 pesos thereabout. So if you are taking 36 pesos off a liter of petrol, that technically means that petrol will still be within the 14 cedis range. If what the oil marketing companies are saying is anything to go by. It is diesel that they had indicated diesel was going to go up from 17 cedis 10 pesos to 18 cedis 30 pesos. So with what you're saying, that's per liter, by the way. So if 2 cedis is going to go off diesel, then that would bring it down to about 16 cedis thereabout. But petrol will still be within 14 cedis, that 14 cedis bracket. So those who are asking for the fairness in this distribution of the intervention, why so much for diesel and 36 pesos for petrol when you have more vehicles using petrol than diesel?
Well, for the first point is that at least there's no denial that the government has intervened to cushion consumers. And so no matter how nominal it will be when it comes to that of petrol, at least there's no denial that there's been an intervention. And without that intervention, what it will mean is that consumers would have paid more. The decision to intervene heavily when it comes to diesel, if you look at the data, the data shows clearly, and you can check with the NPA, that consumption when it comes to diesel is more than what petrol is. And then also number two, if you look at the price currently, the differentials between petrol and diesel as we speak is very, very significant. It's around 4 Ghana cedis, depending on the OMC you purchase from, which is a lot. Normally, yes, you see price difference between the two products, but not that wide a margin. The last time we witnessed this would be when
we need and some so our political highway so a year OSP kisi ejabe what take quick action after a year High Court ruling on a year in the prosecutorial powers. Abuzia yabada say some Japan kokoti sa in some way at my a gossip politics TV. There is much interesting moment ahead. Any update to be able dropping or I see at the ama yabe for madam.